Are you aware of the facts of this case?
No, Lordship. Just now, Director has instructed me to appear, Lordship. Just now.
Just now, the director of NJIOS.
Let me give some time.
You do one thing. You just find out from the NIOJS. What is it?
NIOS.
NIOS office.
Yes.
About the registration process and whether they keep the records. Right. This is with respect to some of the aspirants who have only 18 months of diploma, which has been permitted by a Supreme Court judgment. But then the state, to a large extent, rightly says that we need to verify whether these are the persons who are real, 18 months diploma holders while teaching in a school. Now, anybody can't. And you don't even permit. You'll have to go through the brief. Otherwise, it'll all appear very abstract to you.
Lordship.
But the matter is urgent. You find out and tell us next week.
What we can do, we'll supply a set of the writ appeal.
Please.
Today,
Take down.
or tomorrow morning at 10:30 we'll hand over because it'll bulky paper.
Yes, Mr. Arvind.
I would like to make a small submission.
Yes.
Now, in the writ proceedings, a particular pleadings were there. They filed a writ appeal without the basic document.
Yes.
Which also Lordship has condoned. Now they want
we
to...
have not condoned. We will take it into account.
Yes. Okay, Lord. Now they are bringing some additional affidavits, whether they have taken the leave of the court or not, because that is not permissible. I have series of judgments on appropriate time I will place that if new facts are to be brought at the level of appeal, intra-court appeal, then there has to be a leave granted by the division bench, which they have not done till now. If Lordship gives them the leave to bring the additional facts, then Lordship will give us notice, then we can rebut by filing a counter affidavit.
That objection is sustained.
Deeply obliged.
Take down.
I just need 5 minutes of my lord's comment.
There is a division bench judgment of our High Court, Miller. I made this submission. This was rejected, and new facts can be brought in because it is only an intra-court appeal. It is continuation of the original.
But then we have to give some.
Yes. But just point of information. Yes. I'll place the judgment, Miller.
Post filing the additional documents,
Yes.
which were not part of the writ record,
Yes.
we have to give them time, no?
Of course. And we have served these copies when? At the filing, they could have filed a reply to that. They have not filed till. It is not that we have not served them a copy.
Mr. Advocate General raises a preliminary objection. So
Yes.
we accept this affidavit for a proper determination of the case, and we grant you post facto leave with the liberty to the Advocate General to
I
respond.
was not sure whether they are going to press it or not. Today they have pressed it. So I have raised the objection at the appropriate time.
Mr. Saikia, we have sustained your objection.
Highly obliged, Lord.
Even otherwise, the matter will not be heard.
This situation sustained, we often come across in Hindi movies. Objection overruled.
I have used this expression after 10 years.
But we enjoy that expression when we see it in the movie as well as in the court.
Can I just take 5 minutes of my lord's time if my lord would permit?
Yes, what do you want to say?
Well, there are about 6 applications listed today, and I had the privilege to assist the learned single judge in this very matter, my lord. The Honorable Supreme Court had passed the order, my lord. I just need 5 minutes by what. I'm not taking my lord through any of the documents, but just wanted to give a brief background because the Honorable Supreme Court, I had the privilege of assisting the Honorable Supreme Court also in the very same matter.
Mr. Kalra, you address us on the next date.
Yes. Can I just take 2 minutes, my lord? Can I just take 2 minutes?
That would not be necessary. On the next date, we'll give you 20 minutes. Don't worry.
Very well. My lord, then, my lord, may kindly be pleased to issue notice in my application because these applications are for impleadment because some of the parties were there before the single judge and some are similarly placed.
That may not be necessary. They will decide it on principle. That may not be necessary. We will decide it on principle. We will deal with your IA. We'll deal with your IA, no doubts.
Very well. Very well, my lord. And there is one last thing that I wanted to say, if my lord would permit. I had mentioned on the last day, my lord, that after the learned single judge's order, there has been another judgment of the Honorable Supreme Court in the very same issue, where the Honorable Supreme Court has observed that relying upon one document, which is an experience certificate as certified by the government of India.
You had said that on that day. We remember.
Yes, my lord.
You had said that.
That needs to be taken. And the last thing is, my lord, some interim prayer today needs to be considered, my lord. The reason is this, my lord, that most of the appointment letters have already been issued by the government.
No, we have already
Now,
made
today
it subject. We have already made it. Any future appointment letter will carry that caveat.
That may be continued, my lord. That interim protection may be.
Of course.
Unless we resigned it, it shall continue, Mr. Kalra.
Very well, very well.
Don't worry about that. See, question is this. Now, we also must get satisfied that you people are genuine people who would require this kind of concession.
Lord, I will
Now,
show
if
from the
you-
document.
That's
I
why.
will show from the document
We are not-
that
are we-
this verification.
Mr.
This
Kalra, are we
verification.
Mr. Kalra, are we
Very well.
concluding today? We are not. We are not
Very well.
concluding today.
Very well.
See, because the past experience has not been good. Past experience of the governments have not been good, especially in the Department of Education. And
I
therefore,
understand that.
utmost care has to be taken with the balance. That
I understand
person who deserves to be considered, he can't be shut out. So therefore,
I understand that, my lord.
let
Just
me
one
get-
thing, if I can add. If one thing I can add.
Mr. Kalra, you are too full of the facts of your case. We understand that. We appreciate that also. We appreciate it, but then just don't take out, bit by bit from your sleeves. We will jot it down at one place, and when we give you the opportunity to address us, with an open mind, we'll be hearing you. All right?
Very well, my lord. So grateful.
No, I said don't take it out from your sleeve every now and then. Huh? Take care. During the course of hearing of this matter, of these set of appeals, we realized that NIOS, though has been made a party, was not noticed. We sent for the Standing Council for NIOS, who has presented herself before this court and has submitted that she would be taking instructions with respect to factual averments made in the appeals and shall get back to this court by the next date. A copy of the main memo of appeal along with the annexures shall be handed over by Mr. Ken Chaudhary, learned senior advocate, leading the arguments on behalf of the appellants, to her
By tomorrow at 10:30.
by tomorrow at 10:30. By tomorrow morning. Mr. Chaudhary, while addressing this court, also referred to certain additional affidavits, also referred to an additional affidavit filed before this court in this appeal on 13 October 2020.
13/10/25.
On 13/10/2025, the learned advocate general raising objection to the maintainability, to the admissibility, learned advocate general, the learned advocate general, however, submits that without the leave of the court, these additional facts and documents could not have been brought on record, and if at all any ex post facto leave is granted for bringing those affidavit, by bringing that affidavit on record, the state shall have the responsibility, the state shall have the liberty to rebut the factual position. Be that as it may, the additional affidavit, the contents of the additional affidavit are not yet fully known to us. We, for reasons of effective determination of the dispute here, permit it to be taken on record. And we simultaneously grant liberty to the learned advocate general to rebut the facts stated therein, if so desired by the next date. The issue pertains to the eligibility of the appellants for being considered for appointment to the post of teachers especially in view of the fact that they have only 18 months diploma instead of 2-year diploma in elementary education system. By virtue of a judgment of Supreme Court in its review jurisdiction, in the present appointment process, such candidates having 18 months diploma from National, what is NIOS, what is the full form?
NIOS.
National Institute of Open Schooling.
National Institute of Open Schooling.
Open Schooling.
Open Schooling, bracket NIOS. What did I say? I couldn't get the link line. Start from. In the present appointment process, are permitted to participate. However, the state in its education department has asked for further confirmatory facts relating to their entitlement as aspirants for the said post, which is being opposed by the appellants, which objection was turned down by the learned single judge. Hence this appeal. Stop. It is in this context that we would require effective assistance of MS
RB Bora.
RB Borbora or RB Bora?
RB Bora.
RB Bora, learned standing counsel for the NIOS, especially the fact whether NIOS maintains or has in its records the names of the schools with their UDISC code, even though temporarily granted, in which the appellants were employed as teachers when they were recommended for 18 months diploma course. The details of the records of such teachers who obtained 18 months diploma, if available, ought to be brought on record by the next state. Re-notify.
Only one thing. Now NIS has been asked to give the credentials of those schools. Their schools are not proper. They have to properly identify those schools.
And that you do. But provided, see, question is that you are asking for those details. They say that it was deactivated. Now,
For which school?
so therefore,
X may be a school,
therefore-
whether that X school has been deactivated or not.
so unless they have the record of that UDISC code number of such schools whose teachers were permitted, I think they don't have a case.
Yes.
Then
No, Lordship, in Assam, we have 45,000 elementary schools. So whether all the records of those schools will be required in this evidence?
No. Records which are essential. You have learned it. It is with respect to these appellants.
Who are the appellants?
Appellants only. For the appellants. Just write for the appellants.
Both the applicants as well, my lord.
Appellants/applicants.
I'm so grateful.
But they have to identify their, because
Yes.
they have to identify their schools.
See, if you have the Mr. Chaudhary, even if it has been deactivated, we would like to know whether you were teaching in the school. Where anybody
Those certificates are there, my lord.
Point number 7 is there.
All right.
And my lord, I'll address the lordships on that.
All right. Next, when do we place it?
Depending on
I need 4 weeks time. Because they have mentioned about 68 schools, we have to find out the credentials.
All right. So
I think 4 weeks will be too long. Let it be.
all appointments made shall be with the cabinet.
Yeah, in our appointment order, we have very categorically mentioned that.
And it was offered on behalf of the Advocate General only. We didn't have this idea. He only said that it will carry that line.
Yes, Lordship, which would be fair.
Let it be maybe 2 weeks or 3 weeks. End of the day, Milord, these are all contentious matters.
These are, but we will keep it as first case on the reopening after winter holiday.
Let it be in December, Milord.
All right. December first week, this bench is not available.
Second is, Milord.
Second week, they'll not be ready. And third week again, I'm not there. Anyway, we keep it on 18th of December.
So from 14 to 18, I am not available. 19th or 20, whatever it was.
19 is the last voting.
19th. Let it be 19th.
19th, you'll be here.
Yes, Lordship.
Last day when the court closes.
I'll come, Lordship. No issues. No difficulty.
Can we pray?
Can we not keep it in the first week of January?
I have no objection.
First week, January is all closed here in Assam.
I'll be here, Lordship. I mean, if the court is open, I'll be here.
If it is otherwise not inconvenient, could it be on 8th of December, Milord?
No.
8th of December. Fine, no, I'll let time.
8th week, can you collate all the information
Yes.
by 8th?
If she is not in a position, Lordship will accommodate her.
To a 12th of December, Lordship, if it is not inconvenient.
All right, 12th of December.
Grateful, my lord, deeply grateful.
Item
Item number 8.
Lordship,